The Supreme Court of the United States is the highest court in the federal judiciary of the United States of America. It has ultimate appellate jurisdiction over all federal and state court cases that involve a point of federal law, and original jurisdiction over a narrow range of cases. Specifically, all cases affecting ambassadors, other public ministers and consuls, and those in which a state shall be party. The court holds the power of judicial review, the ability to invalidate a statute for violating a provision of the Constitution. It is also able to strike down presidential directives for violating either the Constitution or statutory law. However, it may act only within the context of a case in an area of law over which it has jurisdiction. The court may decide cases having political overtones, but it has ruled that it does not have power to decide non-justiciable political questions. Established by Article 3 of the United States Constitution, the composition and procedures of the Supreme Court were initially established by the First Congress through the Judiciary Act of 1789. As later said by the Judiciary Act of 1869, the court consists of the Chief Justice of the United States and 8 associate justices. Each justice has lifetime tenure, meaning they remain on the court until they resign, retire, die, or are removed from office. When a vacancy occurs, the President, with the advice and consent of the Senate, appoints a new justice. Each justice has a single vote in deciding the cases argued before it. When in majority, the Chief Justice decides who writes the opinion of the court. Otherwise, the most senior justice in the majority assigns the task of writing the opinion. The court meets in the Supreme Court building in Washington, D.C. Its law enforcement arm is the Supreme Court Police. It was while debating the separation of powers between the legislative and executive departments that delegates to the 1787 Constitutional Convention established the parameters for the national judiciary. Creating a third branch of government was a novel idea. In the English tradition, judicial matters had been treated as an aspect of royal authority. Early on, the delegates who were opposed to having a strong central government argued that national laws could be enforced by state courts, while others, including James Madison, advocated for a national judicial authority consisting of various tribunals chosen by the national legislature. It was also proposed that the judiciary should have a role in checking the executive's power to veto or revise laws. In the end, the framers compromised by sketching only a general outline of the judiciary, vesting federal judicial power in one Supreme Court, and in such inferior courts as the Congress may from time to time ordain and establish. They delineated neither the exact powers and prerogatives of the Supreme Court nor the organization of the judicial branch as a whole. The first United States Congress provided the detailed organization of a federal judiciary through the Judiciary Act of 1789. The Supreme Court, the country's highest judicial tribunal, was to sit in the nation's capital and would initially be composed of a Chief Justice and 5 associate justices. The Act also divided the country into judicial districts, which were in turn organized into circuits. Justices were required to ride circuit and hold circuit court twice a year in their assigned judicial district. Immediately after signing the act into law, President George Washington nominated the following people to serve on the court: John Jay for Chief Justice and John Rutledge, William Cushing, Robert H. Harrison, James Wilson, and John Blair Jr. as Associate Justices. All 6 were confirmed by the Senate on September 26, 1789. Harrison, however, declined to serve. In his place, Washington later nominated James I. Riddell. The Supreme Court held its inaugural session from February 2 through February 10, 1790, at the Royal Exchange in New York City, then the U.S. Capitol. A second session was held there in August 1790. The earliest sessions of the court were devoted to organizational proceedings, as the first cases did not reach it until 1791. When the nation's capital was moved to Philadelphia in 1790, the Supreme Court did so as well. After initially meeting at Independence Hall, the court established its chambers at City Hall, under Chief Justices J. Rutledge and Ellsworth. However, Congress has always allowed less than the court's full membership to make decisions. Starting with a quorum of 4 justices in 1789, the court lacked a home of its own and had little prestige. A situation not helped by the era's highest-profile case, Chisholm v. Georgia, which was reversed within 2 years by the adoption of the 11th Amendment. The court's power and prestige grew substantially during the Marshall Court. The Marshall Court also ended the practice of each justice issuing his opinion seriatim, e.